We're sitting here at Fred Niemann, partner in Hanlon and Niemann, and in discussing a little bit about elder care. One of the interesting things that I think people miss is that the timing of doing planning. And we talked a little bit previously about crisis mode and so forth, and the timing of making transfers or trying to protect assets is significant. So, Fred, why don't you tell us a little bit about what the timing issues are, and maybe a little bit even more on the control issues as well as we go through it.
Probably the most frequently stated comment to me when people call for a crisis meeting is, I wish I had come and seen you a couple years ago. And then the other most frequent thing that I say to them is, you're too young, get out of here, come back and see me in a couple years, because I'm not comfortable with you transferring everything to your kids when you're only in your late 60s or early 70s. So the decision to protect assets or your life savings is one which I think is directed by a whole bunch of things. It isn't just the dollar value of your estate, it isn't your age. Because I say to folks, and I say it to them sincerely but very directly, if you're lucky and you live a long life and you die quickly, you don't have to do asset protection planning. Problem is, none of us knows when we're going to die or how we're going to die.
We don't get that multiple choice question.
We don't get and
I'll sign up for this one.
Exactly. I mean, I always say to them, my sincerest wish for you is that you die either a young old man or an old young man, but that you don't linger and suffer like a lot of folks do. And that's always the tension is what will the years bring? And does it make sense? Is it in your best interest to try to protect what you've got? If someone's diagnosed with early onset dementia, for example, we know the future is not going to be good. We know that the disease will slowly take away the person's dignity and eventually their competency. So in that situation, the reasons for planning are obvious. Time is not on our side, and the way the law is written now, if you want to transfer assets to a family member, your children, to a charity, to anybody but yourself or your spouse, the state will penalize you dollar for dollar for any gift made within 5 years of the date you apply for some form of public assistance to pay for your long-term care costs. They don't care if it's money written to the Haitian Relief Fund, your local church, your granddaughter's wedding. If it's within 5 years, the burden will be on you to justify that transfer. So we're always looking at what I call the 5-year clock. And can we get by that 5-year clock if we transfer assets? And the other thing that folks have to understand is when you transfer assets, how should you transfer them? Should you transfer them outright to a child or to someone? Or should you transfer it in a form of a trust? And the answer to that question is a function of your family in many respects. Do you trust your children? Do your children get along? If you transfer it to your children and they, God forbid, should die, if they have a will it go to their spouse or your in-law? Or will it go to their children? Those are concerns. If a child were to get divorced, what would happen to money transferred? So if a family has just one child or two children and everybody is really on the same page, there's less formality, perhaps. But in order to really do what needs to be done in a way where I'm comfortable for the long-term welfare of the client, the aging person, and or the integrity of the planning process, I generally recommend it goes into a form of a trust. But the parents have to understand that when they transfer it to someone else to start that 5-year clock, they no longer own it. And that's something that's hard for them to understand. A lot of times I'll use an example. I'll take a dollar bill out and I'll hand it to him. And if I had a dollar bill, Frank, right now, I'd hand you the dollar bill and you'd take possession, then that's a gift. But if the dollar bill I give you has a string attached to it, and I can pull that dollar bill out of your hand, well, then it's not a gift. It's not known as a completed gift. So Medicaid and the laws of our state and the federal regulations look to the bona fides of what you do. And if it's not structured the right way, they'll look to invalidate it, which means that should you require long-term care costs that are prohibitive, they're going to make you spend down everything to $2,000. Most people don't realize to qualify for Medicaid today for long-term care, you cannot have more than $2,000 left.
It's not much money.
Not much money. So if you're worth, say, $800,000, and you may say, well, that's a lot of money, I should be fine. Well, if you have early onset dementia and you need to go to assisted living with the memory impaired unit, you're looking at a $7,000 a month tab. If it's a nursing home, you're looking at anywhere from $8,500 to $12,000 a month. And that's just for one person. So you multiply that out by the number of years of a person's life expectancy, and all of a sudden, what looked to be a generous amount of life savings is less generous. And so folks worry about that, and the kids in particular worry about that because the kids were hoping for an inheritance, and many of the parents want to leave them an inheritance. So it's really the middle class and the upper middle class who, for lack of a better word today, are getting screwed. They're living longer. The only mistake they ever made was living too long, getting sick, and saving their whole life for the reasons of providing for family and spouses and children. And now it's all at risk when that crisis diagnosis is made.
It's interesting is, my experience over the years is that, when someone's built up assets like that, they feel pretty good. And then when we would have the conversation with them, we say, well, what happens if it's one of the spouses? So, you had X amount of dollars and for two people to live on, it's fine. But if all of a sudden one person gets sick and they're going to need care, it really does hinder the ability of the other spouse, the healthy spouse, to continue to maintain their lifestyle and so forth.
Yeah.
And I would imagine that's something that you help in the planning process. That's one of the things that you identify.
And for example, Frank, if you're a husband and wife, the most that New Jersey will let you keep of non-exempt resources is $109,000. So if you have over $220,000, they want you to spend every single penny above that towards your care costs before the community spouse will be able to then apply for Medicaid for the institutional spouse. And the income limits are modest at best. What they'll allow the community spouse to keep is modest. But the good news is the elder law bar in New Jersey has sued the state very successfully in federal court to protect the planning opportunities under federal law. The state director of senior services, health and senior services, is determined to bankrupt every middle class and upper middle class family. The courts of New Jersey have bought into it. And so what lawyers have done in New Jersey is to sue the state in federal district court to have the federal judges uphold the rights of families to these planning opportunities under federal law. And now New Jersey has been forced, though they fight us every step of the way, in recognizing how we can keep more than that $109,000. I'll say to people, it may not look the same when I get done. In other words, you may have X dollars, and when you get done, you won't have X dollars left. But I'll take the excess money and convert it into income or some other means so that I can enhance and keep your quality of life as high as I possibly can. And so that's one of the benefits of what we do. But when you're single, it's really, really tough because there's very few options out there, and some of those options that are out there are probably too complicated for me to explain here this afternoon. And so what I'll tell folks is we really need to try to get by that 5-year clock. And then if that's a question called into question, then I got to do some more serious, very aggressive crisis techniques to try to save something for single persons.
As I listen to this, you can tell that it's really a very specialized area of law and of planning. And it's important that they get to a qualified individual when they're doing that. It's not that regular, general practitioner in a law office and so forth. It's someone who actually has some expertise in elder care planning and so forth. From a credentialing standpoint, is there a difference in someone who does elder care law versus general practice?
Yeah, I wasn't always an elder attorney, but I've always been involved in the business side of law, as well as being a trial attorney for a lot of years. And that's one benefit, because when the county and or state tries to play hardball, if you're not a trial guy, you're afraid to go to court. I'm not afraid to go to court. I'm not afraid to try cases, because that was my background. But you got to really understand financial planning. I've always been, like I say, fairly involved with business. The role of the financial planner is really, really important. In fact, they're probably the most trusted person next to the accountant to the family. And the financial planners really need to understand how much their clients are at risk, and because when the money's spent for long-term care, there's no more money to invest. And when you're out of money, you're out of options. And so you really need an understanding of the stock market, of bonds, of annuities, of the various financial instruments and investments out there. You have to have somewhat of a vocabulary. I need to be able to speak to you in financial planners speak. You have to understand the tax consequences of everything you do, and then you got to understand the consequences of qualifying someone for veterans benefits without jeopardizing their eligibility for Medicaid in the future, because the two are mutually exclusive. A lot of folks don't realize that the tax code and the law involving Medicaid are mutually exclusive. Medicaid doesn't recognize the tax laws, and they're not bound to. And so many of the beliefs that families have concerning the protectability or the taxability or the eligibility of different types of things is blown apart when they come to see me, because I have to explain to them that while their understanding of the concept was correct, it's not binding on the state of New Jersey.
Right.
And then, of course, the level of anxiety goes up dramatically when you start talking about that stuff.
Well, I got to tell you, Fred, it's been great having you here on our program today, and it's been so insightful, as far as, some of the information as it relates to elder care, veterans benefits, and so forth, and we thank you so much for that. And we thank all of you for joining us here on the Institute of Responsible Wealth, and we look forward to spending additional programs with you going forward. Thank you.